618, Mr. Ben Reed, Ms. Sherry Castillo, Mr. Jacob Gauna, Mr. Fred Gonzalez, Mr. Roy Edrock, Mr. Johnny Rodriguez, myself, Daniel Tejada. Also joined our EDC attorney, Silvia Rodriguez, our city managers with us, Councilmember Gloria Martinez, Councilmember Juan Ortiz, who else? And various guests from the community. Mr. Gonzalez, would you lead us in prayer, please?
Yes, I will. Please rise. Let us pray. Heavenly Father, as we begin our FEDC meeting, we ask, as always, that you be with us. We thank you for your many blessings. And as we near that wonderful time of the year when we commemorate the resurrection of the Christ and your promise to him of eternal life, we especially thank you. As your servants and servants of the Floresville city, we ask that you guide and help us in carrying out the town's business. May we always be mindful of our obligations to the citizens of Floresville, and may we carry them out with responsiveness and honor. We ask this in your Son's name. Amen.
Amen.
U.S. pledge.
Pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Under the Texas flag, I pledge allegiance to thee, Texas, one state, under God, one and indivisible.
Well, thank you again for everybody showing up on this Thursday night, right before a holiday. First of all, any citizens' comments? Mr. Carvahal, would you want to mention your business that's coming up?
Thank you very much. I appreciate you recognizing me. My name is Alan Carvahal. I'm the grandson of Oscar Carvahal from his first wife. I purchased his old saddle company from Mr. Chris Trevino, and I'm looking forward to getting it up and running, hopefully before Peanut Festival, but that might be a little bit aggressive. But thank you very much.
Thank you. Thank you for being here.
Welcome.
Okay, old business. We have an action item. It was 288 to approve meeting minutes of the regular board meeting held on March 11th. However, if you remember, there was a motion at that time to approve as amended, and Ms. Silvia Rodriguez has provided the amended copy to us. You should have that in front of you. So if we could just have a motion or of an action that there's not going to be any type of action taken for that, because we have the amended already, and that was already done on March 11th.
And may I point something out though on this? I prepared y'all some minutes here of the March 11th meeting pertaining to that item. And the reason I did it was because it was under your instructions at the April 8th meeting where you said for me to go back and insert that language into the minutes. And so when I went back, I didn't find any of that language in the minutes. And so I copied as best as I could. I'm not a transcriber, but as best as I could verbatim of what I heard on that tape. And in it, you have before you those minutes, and nowhere does it state what you asked me to reiterate at that meeting in the past meeting.
And if I may just real quickly respond to that, if I may, Mr. President and Board of Directors, we actually, what I did was I obtained a copy of the audio recording, okay? So what I did, I listened to them. There was some confusion, and the reason that I had asked for a copy of the audio recordings was because my colleague, I wasn't here, I was told that there possibly was some confusion and that the minutes had been tabled, that there were issues with the minutes. So I finally obtained a copy of the minutes. I listened to the minutes. My understanding at one time, Mr. Reed, you put a motion to table it. It was second, but those were later rescinded with the agreement, the specific agreement that Mr. Rodriguez stated that he could not move due to a familiar hardship. That was the agreement. There was then a motion made by Fred Gonzalez, second by Sherry Castillo, and with the amendment, cannot move due to familiar hardship. And then after that, it was put to a vote. It was a 6-0. They were approved. They were done. That's the only amendment that was done to any of the minutes, and that's the only amendment that was done. They've been approved, no further action needs to be taken tonight.
That was on March 11, 2019, 6:30 PM when we went into the meeting? Is that correct, Council? For March 11, 2019?
If they were done, you would have those notes, and I would have notes too.
But I'm saying you're referring to that, is that correct?
I'm referring to the minutes
Yes.
of
that's
that,
exactly
they've
what I
already
wanted to
been
do.
done. And my advice to the Board of Directors is we've already taken care of that issue. It is moved for today, you need to go forward and then continue on with the agenda.
Okay, well, there's something I need to get on the record, though, because on page 4 of those minutes that I provided to you, I state, Rodriguez replied, "I can't make that commitment right now. I would not have put this item on the agenda if that was the case." And I also stated, when Danny stated, "Johnny, are you asking for an extension?" And I said, "No, I am asking for elimination of that clause from my contract." I was pretty clear, and when you asked me the question you did, you kind of surprised
And
me,
if I may,
because I didn't know what to say.
if I may, without being, I don't want to be disrespectful to
No, not
Mr.
at all,
Rodriguez.
Counsel, not at all.
And I apologize,
Perfect. Yes,
Mr.
ma'am.
Rodriguez.
That's
Nothing
okay.
personal, and
No, not at
I
all.
apologize, sir. But those minutes, like I have indicated, they have been approved, they've been voted on. There was an amendment that was done, it was a 6-0 vote. That issue really honestly is married. We need to move on and proceed with the rest of the
Okay, that was
agenda.
done on the April 8th meeting.
Yes, it
correct?
was.
Yes,
Yes, it was.
not in March.
No, it was
Okay,
at the
thank
April
you.
8th.
Okay.
And that was the only amendment that was done.
Right.
All the other minutes stood as they were presented.
Let's go on to item 2, executive session. The FEDC will convene an executive session pursuant to section 551.074 of the Texas Government Code, personal matters to deliberate the appointment, employment, evaluation, duties, discipline, or dismissal of a public officer or employee, executive director's employment agreement. Did you want to go into closed session, Johnny, or open session?
No, I'd like to keep it an open session and keep it transparent.
Okay,
I want the people to see what's going on, what's happening in the process.
okay.
Yes.
Who said it's to hear?
And this is Mr. Roger Guevara, who's my attorney.
This is-
What was the name? The name?
Roger Guevara. Mr. Roger Guevara.
You got it.
Guevara, correct?
Okay, Johnny, you've indicated twice to this board on March 11th and April the 8th that, from my understanding, from what I recall, that your intentions are not to move. And this meeting here is to give us your status, your intentions. So the floor is yours, sir.
May I say, on behalf of Mr. Rodriguez, and I've consulted with my client, it's my understanding that according to the contract, he's got till June, on or about June the 2nd, to decide whether he wants to move into Floresville. I understand he's got some family issues. I believe his father-in-law is ill, and that's what is causing him to delay and making a decision whether he can move. But I think that based on the contract that y'all have with Mr. Rodriguez, it'd be premature really to get Mr. Rodriguez to commit himself one way or the other.
And if I
Well,
may, if I may,
Sure.
Mr. President, and just interject, just
Sure.
really, really quickly, without interrupting you,
Sure.
Mr. Guevara. The reason I believe that the board has concerns and they had requested was because back in March, your client, Mr. Johnny Rodriguez, indicated that he was putting the board, the FEDC board on notice that he was not gonna be able to move. That was at the March. At the April 8th meeting, he made a statement after my colleague indicated something to the effect, we have to address the elephant in the room. The statement was by your client, I will entertain a buyout if you want to get rid of me or something, that is fine with me. And I think that that has been concerning to the board of directors and concerning enough to come forward at this time and ask for it to be discussed. Am I correct, board of directors, or am I misspoken?
You're correct.
You're correct.
That being said, you know, I still think that, you know, we have a legal binding contract here, and he has until June to make a decision. I think that if he is, you know, he at this point, or is just expressing his concerns about his familial situation, but the problem is that it's real difficult for him to decide according to Mr. Rodriguez. Now, I would think they would be premature to terminate this contract in any other way. I think that the contract speaks for itself too, and I think that the contract, especially under section 19E, talks about you know, if an agreement, this agreement should not be modified or amended except by approval of the majority of the entire board and executed in writing by Mr. Rodriguez. So therefore, using that language, I think that you know, the concerns that the board may have, if the board decides to do anything, I think that it would have to discuss this, I guess, and see about either modifying the agreement or, I guess, waiting until the contract, until June 2nd comes about and see about.
And if I may, I think that the modification or the waiver of the relocation was put at hand, was put on the agenda. And my understanding is, if I am not correct, if you could please correct me if so. But my understanding is that at that time, there was no motion, and it died for lack of promotion and died for lack of a second. So my understanding is the contract does stand as is, and the board of directors of the FEDC have not agreed to waive the relocation agreement. Is that correct?
That's correct.
Okay.
But in the law, we have what's called an anticipatory breach, and that's what we're looking at this point, because you know, if the board is thinking of taking any action concerning whether Mr. Rodriguez moves or not, then the board may be in breach of contract.
Now, also, Mr. Guevara, I would like for you to take into consideration that this board was put on notice back in March that with strong words that were utilized that said, I am putting you on notice that I am not moving. That was done in March. We're now in April.
And that
is why, and I
that may
agree,
be true.
and that's where I believe the board anticipated back in March that there was going to be a breach of contract on behalf of your client. And that's why they wanted clarification, and they wanted, and one of the issues that needed to be clarified was, would the board of directors want to waive the relocation?
But you may be correct, but well, what I'm saying is that the breach has not occurred under the contract.
That's debatable, debatable, but I'm sure that.
I mean, I've read the contract. I mean, I'll say, has Mr. Rodriguez abided with the state law?
I don't think that we're set to go into any questioning and stuff of that nature. I think we just, am I correct, Mr. President, was the board wanting clarification because of the statements that were made at the last week's meeting that indicated that he wanted a buyout, or that he wanted something to that effect? Am I correct?
I think we could have that discussion, yeah, it was brought up.
Okay, and it was asked at that time if a special meeting could be heard during this week. Is that correct?
That's correct.
And is that what has taken place?
Well, I mean, if that's what the board wants to discuss, a potential buyout, I mean, you know, I don't think that, you know, we're gonna oppose that. You know, we're open, but I don't think that, just to make clear, I don't think there's a breach of contract.
And of course, that's gonna be debatable, but what I think, if there's not gonna be any further clarification, Mr. President, and it's up to the council or to the board, y'all are in charge, I'm just the attorney here on the corner, but if there is not gonna be any further discussion regarding the agreement, I don't believe there's any further business. I think the agenda just said to discuss the agreement, it doesn't say consideration and action at this time. Board?
Any other discussion, any other comments?
Not at this time.
Mr. Attorney, would you like to say anything else?
Well, you know, basically, I mean, I think that we're talking here about a legal binding contract, and, you know, the terms of the contract are pretty clear. I mean, they're written in black and white, and, you know, one can say, you know, I may not be able to do this, or, you know, I'm not going to do this if this happens, but the thing is that he still has a deadline to be, put into the contract. And so therefore, when that deadline comes, well, what if he decides to get and move tomorrow or the day after? You know, then, you know, the board has taken premature action, and that's my point. So that's the argument that I think that the board needs to consider, is that we may be jumping the gun here, but at the same time, you know, I mean, we're here, and Mr. Rodriguez, I think, is open, and I talked to the attorney that is present here, and I believe she represents the board. And so, you know, we, at this point, we'll leave it open for discussion.
Attorney, would like to finish off?
Basically, yes, sir.
Can you clarify for me section 14?
Yes, sir. Okay, Mr. Gowda, section 14 basically has different subsections under it. Is there a particular one that you would like clarified, or is that?
Well, I was just reading the,
Do you want me to go
Please.
paragraph by paragraph?
Please.
Okay. Section 14 of Mr. Rodriguez contract deals with termination and resignation. Says the parties agree that Mr. Rodriguez serves at the will and pleasure of the entire board, and the entire board being FEDC. And on a majority vote of the entire board may terminate this agreement and his employment with the FEDC, subject to the terms and conditions of section 14. Then you have subsection A, which talks about termination with cause and what could occur if a court was to make a finding that there was no cause, okay? What could occur at that time if there was no cause? A lump sum payment of 6 months could occur. And then if you go under subsection B, termination for cause, that basically gives you different sections as to what is determined to be with cause, okay? It also indicates, I'm sure, if it's terminated without cause, then there's no obligation to pay any severance, if that's for cause, okay? It goes on to discuss subsection C, suspension and administrative leave, certain things that could occur that the FEDC may wish to do or has the power to do, and it talks about how that would be handled. Subsection D talks about voluntary resignation as to what could occur, how many days' notice, and stuff of that nature. And then E talks about the reduction of salary and benefits. Okay, but I think that, is that pretty good, Mr. Howard?
Yes, sir.
Okay,
Thank you.
yes, sir.
Do you see any need for us to go into closed session?
No, sir, I do not, not
Okay.
at this time.
Okay, there being no further business, the meeting is adjourned at 6:36.
I'm sorry, would it be inappropriate you've already adjourned the meeting?
Yes, the meeting is adjourned.
I'm sorry, sir.
Yes, sir. Mr.
Thank you.